Welcome to the Santa Fe Distinguished Lecture Series. I'm Ron Duncan Hart, and we are honored to have with us today Dean Erwin Chemerinsky of the University of California, Berkeley Law School. As we start, I would like to thank Marcia Torben for underwriting this program. She's the director of the Santa Fe Jewish Film Festival and a great supporter of the Distinguished Lecture Series. She will introduce Dean Chemerinsky. Thank you, Marcia.
Thank you, Ron. Erwin Chemerinsky is the Dean of Law and the Jesse H. Choper Distinguished Professor of Law at the University of California, Berkeley. He is the author of 19 books, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction. His most recent major books are Worse Than Nothing, The Dangerous Fallacy of Originalism, and Presumed Guilty, How the Supreme Court Empowered the Police and Subverted Civil Rights. He is also the author of more than 200 law review articles. In 2016, he was named a Fellow of the American Academy of Arts and Sciences, and in 2022, he was president of the Association of American Law Schools. Dean Chemerinsky was named the most influential person in legal education in the United States by the National Jurist magazine in 2024. He writes for the New York Times, the Los Angeles Times, and other newspapers across the country, including the Santa Fe New Mexican. He frequently argues appellate cases, including in the United States Supreme Court. He is a leading spokesperson on the issues of freedom of speech, and his forthcoming book, Campus Speech and Academic Freedom with Howard Gilman, will be published later this month. It is with great pleasure that I welcome Dean Erwin Chemerinsky.
Marcia, thank you so much for that very kind introduction. It's truly my great honor and pleasure to again speak with you and to be delivering the Leonard Torben Memorial Lecture. I want to focus, as was just said, on free speech on campus. I want to say a little bit about how the book that I've just written with Howard Gilman came to be. Several years ago, Howard, who's the chancellor at University of California at Irvine, and I taught an undergraduate together on free speech on campus. And we were surprised at how our students' attitudes with regard to free speech were so different from what we expected. And we decided we wanted to write a book about that. We titled it Free Speech on Campus, and it was published by Yale University Press in 2017. And we realized a couple of years ago that so much had happened with regard to free speech on campus that the issues that we had discussed, while still important, didn't relate to the current events. Think about it. A couple of years ago, on December 5th, 2023, 3 university presidents testified before a House committee. 2, the president of the University of Pennsylvania and the president of Harvard University, quickly lost their positions, in large part to the testimony that they gave at that hearing. Or think about how in the spring of 2024, all across the country, there were encampments by pro-Palestinian students. They led to violence in a number of places. Since coming into office on January 20th, 2025, President Trump has launched an initiative against diversity, equity, and inclusion on campuses, including targeting speech that's about this. So we decided we wanted to write not a second edition to Free Speech on Campus, but a new book discussing these topics. And that's what I want to talk about with you this morning. I want to talk about all of these things that have gone on in recent months, in recent years, but put them in a larger context and framework. I thought I'd do this by talking for about 40 minutes or so, and then using the remaining of our time together this morning for questions. And what I want to do is summarize here what I see as the 5 most important principles to focus on with regard to freedom of speech when it comes to college universities. The first of these is that all ideas and views can be expressed on a college campus. Period. The Supreme Court has often said that the very core of the First Amendment is there's no such thing as a false viewpoint, that the First Amendment protects the right of people to express every view, however controversial. And if that's true generally for our society, I believe the place where it's most important is college universities. For them to fulfill their function, it's essential that it be that faculty and students and staff be able to express any idea or viewpoint, whether popular or unpopular, controversial or not controversial. Now, it's important here to keep in mind that the First Amendment to the Constitution applies only to governments and government institutions. Private institutions don't have to comply with the Constitution, including the First Amendment. So the First Amendment itself applies only to state colleges and universities, not to private ones. This is often misunderstood. As I talk with non-lawyer audiences, I realize that one of the most common misconceptions about the Constitution is the failure to realize it applies only to the government. I'll give you a couple of illustrations. Before I came to work at the University of California, I was a professor at Duke Law School in North Carolina. Imagine I had given a speech criticizing the president of the university. Or I guess I should say, imagine I again gave a speech criticizing the president of the university. And imagine he ordered me fired. I couldn't sue him or the university for violating my First Amendment rights. The First Amendment just doesn't apply to a private university. But now I work at the University of California, Berkeley, a state university. If I were to give a speech criticizing the president of the university and he would order me fired, I could sue. You're all my witnesses. I would sue for violating my First Amendment rights. Or my favorite illustration of this is a true story of a conversation I had with my oldest two children 31 years ago when they were, or even a little more than that, when they were 9 and 6, and we were in a grocery store together. Diet Coke was giving away free baseball cards, and 3 cards were pictured on the outside of the package. As we went up and down the aisles of the grocery store, my 2 sons who were 9 and 6 were fighting, as they often did at that age, and it was about who was going to get the extra baseball card. Finally, I said, "Be quiet. I don't want to hear anything else about baseball cards till we leave the grocery store." My then 9-year-old turned to me and said, "You can't tell me to be quiet. I got freedom of speech." I was ready for him. I said, "Freedom of speech means that the government can't tell you to be quiet. I'm not the government, so I can." To which he, without missing a beat, turned to me and said, "Well, you're like the government to me, so you shouldn't be able to tell me to be quiet." That's when I first knew that he was going to someday go to law school, and in fact, he's a lawyer in Los Angeles today. But even though the First Amendment doesn't apply to private college universities, virtually without exception, they express a commitment to follow the principles of the First Amendment. Faculty handbooks, student handbooks that are regarded as contracts to faculty and students, respectively, promise that the universities will protect freedom of speech. Some states, like California, have statutes that limit the ability of private schools to punish speech. Now, when we talk about speech, we're speaking of the First Amendment or of things like contracts or statutes to protect it. There is a related concept when we speak about college universities, and that's academic freedom. Academic freedom is about the freedom of an instructor in teaching, in scholarship, in disseminating ideas within the bounds of what's professionally acceptable. I always think of freedom of speech and academic freedom in a Venn diagram sense of overlapping circles. There's some things that are protected by freedom of speech, but not academic freedom. Some are protected by academic freedom, but not freedom of speech. And there's some, of course, that are protected by both. Let me explain. Imagine that a professor goes to a controversial rally on the weekend and participates in it. And imagine that the professor gets fired for doing so. The professor, if it's state university, certainly has a First Amendment right to do that, but it wouldn't be about academic freedom. Academic freedom is about teaching, scholarship, disseminating of ideas to the public. At the same time, there might be things that are protected by academic freedom that aren't protected by the First Amendment. Think of the teaching or scholarship by a professor at a non-public university. Academic freedom would safeguard that, but not freedom of speech. And of course, there are many things that are protected by both academic freedom and freedom of speech. It's important to always keep in mind that academic freedom, like I'll talk about for freedom of speech, is not absolute. Academic freedom is judged by professional standards. Imagine that I assign a professor to teach contract law. Rather than do so, because the professor doesn't want to, he says he'll go into class every day and he'll just talk about professional sports. I could discipline that professor because academic freedom doesn't safeguard the ability to do that. Imagine a professor who's teaching about 20th century Europe, who's a Holocaust denier. Certainly, the professor has the right outside of the classroom to express that view. That would be protected by the First Amendment. But it's not within the scope of what's professionally acceptable because false ideas to teach it in a history class. Academic freedom wouldn't provide protection there. But the bottom line is that within a college or university campus overall, all ideas and views can be expressed, even controversial ones. My example of the Holocaust denier, certainly that person has the right to express the ideas on campus, even if not teaching 20th century European history. Well, the second principle that I want to cover is that free speech is not absolute. This is true on campuses as well as in society. We're all familiar with the words of the late Justice Oliver Wendell Holmes that there's no right to falsely shout fire in a crowded theater. For example, the Supreme Court has said that child pornography is not speech protected by the First Amendment. People can be criminally punished for possessing it, even in their own homes. When it comes to colleges and universities, there are several categories of unprotected speech that might be relevant. What's important here to keep in mind is that the Supreme Court has defined these categories narrowly. The legal definition is quite different than the colloquial use of the words. One category of speech that's unprotected, they're punished, is incitement of illegal activity. Imagine that there was an angry crowd on campus. Imagine that a speaker exhorted those in the crowd to break windows, to light buildings on fire. I think in these circumstances, the speaker could be punished for inciting illegal activity. As I alluded to a moment ago, there is a legal test for incitement that have to be met in order for the speaker to be punished. It comes from a 1969 Supreme Court case, Brandenburg versus Ohio, and there the Supreme Court said that speech can be punished only if there is a likelihood of imminent illegal activity and only if the speech is directed at causing imminent illegal activity. I think the example I gave a moment ago would fit within this. But you might have seen recently that President Trump issued an executive order that tried to make flag burning illegal. He said it's inherently incitement. The Supreme Court has disagreed. In two cases, in 1989 and 1990, the Supreme Court said that flag burning for political expression is safeguarded by the First Amendment. The Supreme Court has said that for the government to prohibit flag burning, to say that the flag can be used only to communicate a message of patriotism, not a message of dissent. That's discriminating on the basis of viewpoint. And there might be instances where flag burning meets the test for incitement, where it's done in a way that creates a likelihood of imminent illegal activity and is directed at causing imminent illegal activity. But it can't be said that all flag burning meets that test. A second category of speech are what the Supreme Court has said are called true threats. Simply put, there's no right to threaten another person and cause that person to fear for his or her immediate physical safety. The Supreme Court addressed this in a case recently in 2023, Counterman versus Colorado. It involved an individual who sent hundreds of threatening messages to a musician in Colorado. He got prosecuted and convicted of threats. And the Supreme Court, in an opinion by Justice Elena Kagan, made clear that if a person is acting with reckless disregard, how their speech regarded as a threat to another, there's no First Amendment protection. As I said, there's no First Amendment right to cause somebody to fear for his or her safety. To relate it to the college campus, imagine that a student is walking across campus and an angry group surrounds that student and they threaten that student. The student fears that he or she is about to be beaten. Imagine no blows are actually struck. Still, it would be that the students, whoever it was that did this, could be punished. There's no First Amendment right to threaten another. A third category of speech that's not protected by the First Amendment, that's relevant to campuses, is harassment. Let me give the easiest example. Imagine that a professor were to say to a student, "Sleep with me or you'll fail the class." It's no defense for the professor to say, "Well, I was just engaged with speech." Likewise, speech that creates a hostile or an intimidating environment isn't protected by the First Amendment. Now, you'll notice I've given you a few categories of speech that are unprotected: incitement, true threats, harassment. You'll notice what I didn't list as a category of unprotected speech, and that's hate speech. And that's because in the United States, hate speech is generally constitutionally protected. One of the most frequent questions I get when I talk about freedom of speech is, where is the line between free speech and hate speech? And the answer is that's a false distinction, because the Supreme Court has said on many occasions that even vile hate speech is constitutionally protected. As examples, you might remember the instance, now over 4 decades ago, where the Nazi Party wanted to march in Skokie, Illinois. Skokie at the time was predominantly Jewish, suburb of Chicago. Every court to rule, including the Supreme Court, said the Nazis had the right to march there. There was a Supreme Court case in 1992, RAV versus City of St. Paul, and involved a St. Paul, Minnesota ordinance that prohibited burning a cross or painting a swastika, vile symbols of hate, in a manner likely to anger, alarm, or cause resentment. But the Supreme Court unanimously declared that ordinance unconstitutional, saying that hate speech is protected by the First Amendment. Or there's a Supreme Court case in 2003, Virginia versus Black, that involved Virginia law prohibiting cross burning. It did so in light of the awful history in that state of cross burning being used for intimidation. But the Supreme Court ruled that cross burning is speech protected by the First Amendment. This is different from most European countries where there are strict laws that prohibit hate speech. In fact, in the early 1990s, over 360 colleges and universities in the United States adopted hate speech codes. Every one to be considered by a court, without exception, was declared unconstitutional. Why? Why is hate speech protected in this country, but not in so many other countries, especially in Western Europe? I think some of it is that there's not an easy way to define what's hate speech that's not unduly vague or overbroad. Under the First Amendment, any law that regulates speech must be clear about what's prohibited and what's permitted. It can't regulate more speech than the Constitution allows to be regulated. When I taught the undergraduate class on free speech on campus with Howard Gilman, we asked our students as an exercise to try to draft a hate speech code for a college or university that wasn't unduly vague or overbroad. They found that to be an impossible task. I think some of it is also in this country much stronger commitment to freedom of speech, academic freedom than we find in other nations. But above all, I think the reason why hate speech is protected in this country is it expresses an idea. It's an awful idea, but all ideas and views, as I said, are protected by the First Amendment. Now, that doesn't mean that campuses can do nothing when there's hateful speech. If hateful speech rises to the level of creating a hostile or an intimidating environment, then campuses have a legal duty to take action. The action can't be to prohibit and punish the speech. The action has to be to create other ways in order to protect the students, in order to create a learning environment that's conducive for all on campus. Here I want to tell a story of a case that I was involved in as a lawyer. There's a case called Feminist Majority Foundation versus Hurley. It involved Mary Washington University, a public university in Virginia. There was a debate on campus there as to whether to allow Greek life. 3 women wrote an op-ed in the campus newspaper opposing allowing Greek life. They said when there's fraternities on campus, there's more violence against women. They got targeted. There were many hundred messages over the then social media platform Yik Yak. They were threatened with rape and even murder. They went to campus officials, and the campus officials said, "We can't do anything. This is anonymous speech over social media." They sued the university. The federal district court agreed with the university and said that since it was anonymous speech over social media, it was protected by the First Amendment, and the campus didn't have to do anything. I represented the women in the United States Court of Appeals for the Fourth Circuit, and we won. And the Fourth Circuit said that the university couldn't be deliberately indifferent, that the university had to take actions to protect the students. It might have been physical protection for the students. It might have been campus officials condemning the hateful speech. It might have been educational programs. But even when the campus isn't allowed to punish the speech, there are other things that it can do. And in fact, the Office of Civil Rights of the Department of Education said that this is a legal obligation of universities to take action, even when they can't punish the speech itself. The third of the 5 principles that I want to talk about is that campuses can have time, place, and manner restrictions with regard to where and when speech can occur. Even when there's a First Amendment right to use public university for expression, that doesn't mean that it can be used in every space at all times for speech. I'm going to start teaching constitutional law tomorrow morning at 8:30, first day of the semester at Berkeley Law. No one has the right to come into my classroom and shout and use it as the forum for talking about things unrelated to my class. There is a time, place, and manner restriction. Between 8:30 and 10 tomorrow morning, room 105 of the law school can be used only for my constitutional law class. To go beyond this, campuses can say no demonstrations in or near campus buildings while classes are in session. Another example concerns encampments. As I mentioned, as you know, in the spring of 2024, in over 100 universities, there were encampments expressing support for Palestinian rights, opposing Israeli policy. Universities have the ability to prohibit encampments, sleeping in tents on campus property. It's a time, place, and manner restriction. The rules with regard to time, place, and manner restrictions are well established by the Supreme Court. They have to be content neutral. That is, they can't discriminate in terms of what's allowed based on the viewpoint or the subject matter. A campus can't say, no encampments are allowed with regard to pro-Palestinian demonstrations, but allow encampments in terms of other viewpoints. That would violate the Constitution if it was done by a public university. It violate basic principles of free speech for a private university. Also, any time, place, and manner restriction has to leave adequate alternative places for speech. A campus can't say, oh, you can speak, but only several miles away. The restriction has to serve an important interest of the campus. Let me give you an example of what I think is a very important time, place, and manner restriction. And that's campuses having policies preventing disruption of campus activities. There's no First Amendment right to use speech to shout down others. No First Amendment right to have a so-called heckler's veto. You might have heard of some prominent instances of this occurring. There was one at Yale Law School where a speaker from a conservative group, Alliance Defending Freedom, was being shouted down. There was another instance at University of California, San Francisco, where a speaker was shouted down. We have a clear policy in my law school, stated in a free speech message at the beginning of every academic year, that there's no First Amendment right to use speech to shout others down. It says that if you don't like what a speaker is saying, protest in a non-disruptive way. Bring in your own speaker, but disruption would be punished. Otherwise, the only speech that we'll ever hear is that which people don't care enough about to try to shout down. There are hard issues with regard to all of these matters, including with regard to time, place, and manner restrictions. I think one of the hardest unresolved issues is how much does a campus have to pay in security before it can say we can't afford it, so therefore we can't allow the speaker? In the fall of 2017, on the Berkeley campus, a conservative group, calling themselves the Patriots, were going to have a free speech week. And they invited a number of very controversial speakers: Ann Coulter, Charles Murray, Milo Yiannopoulos. And the campus had to pay $4 million in security costs to allow these speakers to go forward. Our then Chancellor, Carol Christ, was kind enough to say, does the campus have to allow them, even though in order to provide security, it'll be so expensive? I said, the law is uncertain here. And I said that I think you've got to decide, what do you want the message to be? If you deny this, you will get sued and criticized for restricting speech. But if you allow it, I know there's a great deal of cost. And every dollar is coming away from teaching or the research mission of the university. She decided she wanted the message to be that Berkeley is a free speech campus and allowed the speech. But it was $4 million. What if it wasn't Free Speech Week? What if it was Free Speech Semester? What if the cost was $40 million? At what point can the university say it's just too expensive to provide security, given our obligation to protect students, staff, and faculty? We have to exclude the speaker. We don't know the answer to that question, and it's a very difficult one. The fourth point that I want to make is that state and federal laws targeting speech about diversity, equity, and inclusion violate the First Amendment. Several years ago, a number of states, all with Republican-controlled state legislatures, adopted laws prohibiting the teaching of critical race theory. And these laws were very broadly worded. They prohibited any teaching about the United States being a racist or sexist country. They prohibited teaching in support of affirmative action. Several courts have declared these unconstitutional. In part, they're unconstitutional because they're unduly vague, but also they're unconstitutional because they're prohibiting a particular viewpoint from being taught. President Trump, upon taking office on January 20th of last year, has taken a number of initiatives to try to stop speech that's encouraging of diversity, equity, and inclusion. A number of courts have declared these unconstitutional, especially as they relate to college and universities. Again, I can talk about a lawsuit that I'm involved in as a lawyer. The case is the Kerr versus Trump. And it involves the Trump administration cutting off literally hundreds of millions of dollars to faculty and researchers at the University of California. And the way this was done, and the government admits it's how it was done, is they did a keyword search. And any grants that use the words diversity or equity and inclusion were terminated. So one of the plaintiffs in my lawsuit was doing research about plant diversity, and the grant was cut off. Another of the researchers was doing diversity with regard to all of the composition of the human stomach and all of the things that protect our digestive system. But the word diversity appeared in the grant, and so the grant was cut off. Besides this being just arbitrary, it violates the First Amendment. In fact, a federal judge in San Francisco, Judge Rita Lynn, ruled in the favor of our clients, saying that cutting off grants based on the perceived viewpoint of the research violates the First Amendment. In the United States Court of Appeals for the Ninth Circuit, in an opinion on August 21st, and another on December 23rd, reaffirmed that the government can't use its tremendous power and leverage to censor particular ideas and viewpoint. It said that's exactly what the Trump administration is doing. Fifth, and finally, I want to talk about all of this in the context of the internet and social media. My basic point is that the same principles with regard to freedom of speech and academic freedom apply in the internet and social media. There's no special rules for this form of communication compared to any other. But it's certainly worth talking about the ways in which the internet and social media create both a golden age for freedom of speech and also a great threat for society. Why do I say that the internet and social media create a golden age for free speech? The internet and social media have democratized the ability people to reach a mass audience. It used to be, in order to reach a large number of people, somebody had to be wealthy enough to own a newspaper or get a broadcast license. Now, anyone with a modem, anyone with a smartphone, anyone with access to the internet and a public library can immediately reach a huge number of people. A crucial part of the First Amendment is the ability to receive information. The internet and social media give us the ability to have access to infinite information instantaneously. In this sense, I think the internet and social media really are about a golden age for free speech. But the internet and social media also pose the possibility and the reality of great harms. There's the ability, by reaching a mass audience, to quickly spread false and defamatory things about a person. It's possible to spread things about a person that invade privacy. Doxing has now become a common phrase. It's certainly possible through the internet and social media to spread information that can cause great harm to society. I'm very concerned about how do we deal with false speech over the internet and social media and all of the harms that false speech can cause. And yet, ultimately, I think that the courts have handled this correctly in saying there's no special rules for the internet and social media. To go through what I was talking about, if speech is unprotected by the First Amendment, then it's unprotected over the internet and social media. That to the extent that the speech poses a clear and present danger of harm, it can be punished in any context, including over the internet and social media. False speech is generally, but not always, protected by the First Amendment. The Supreme Court has said it's important that there be protection of false speech to create the breathing room that free speech needs. On the other hand, there are instances where false speech isn't protected. False commercial advertising is not protected. Lying in court under oath is not protected. Saying false things about a person that injure reputation, defamation, is not protected. And all of that is true over the internet, just the same as it is in any other forum. So the internet, social media, I believe, are the most important tools with regard to freedom of speech that have been created since the printing press was invented. But I don't believe that it creates different rules with regard to freedom of speech or the need for different rules. I realize that a lot of what I've said in going through these 5 principles is controversial. Some believe that there should be more protection of free speech than the courts have given. Some believe that there should be less protection, such as less protection for hate speech or less protection for speech over the internet and social media. I find that my students are more skeptical of freedom of speech than I or my co-author Howard Gilman have traditionally been. I think that's understandable. The civil rights protests of the 1960s, the anti-Vietnam War protests that we participated in college, are as long ago for my students as World War I was for us. My students are much more likely to equate freedom of speech with the vitriol of social media than they are of noble things like the Washington Post uncovering the Watergate scandal. Ultimately, what I try to tell my students is that the only way that their speech can be protected tomorrow is to safeguard the speech that they don't like today. All of us have an impulse to try to stop the speech we don't like. I believe that the First Amendment, freedom of speech more generally, academic freedom are based on a faith. The faith is that we are better off as a society letting all ideas and views be expressed than we would be if we gave government or those in power the ability to pick and choose what we can and can't hear, what we can and can't read. I don't trust those in government, whether it's a Democrat or a Republican, whether it's a president, a governor, or a mayor, a president of a university or dean of a law school, to make the choices about what we can and can't hear or read. And thus, the First Amendment is based on this faith, a faith that we really are better off letting all ideas and views be expressed. There are moments when I have doubts, but overall, I believe that the First Amendment and academic freedom have served this country well for a long period of time, and I hope it will continue for years, decades, centuries into the future. I promised to talk for 40 minutes and then take questions, and that's where we are. So thank you.
Dean Chemerinsky, thank you so much for the enlightening talk. It's raised a number of questions, and I would encourage others, if they do have a question, please put the question in the Q&A box. I just wanted to, before getting into questions from our audience members, I just wanted to talk a little bit more, ask you to talk a little bit more about the effect of the internet and whether we should be maybe rethinking protected speech and what is not protected. And I'm saying this because the idea of a marketplace of ideas is being one of the reasons for advocating for freedom of speech. Even though there is a marketplace of ideas, as individuals today in an internet age, we don't avail ourselves of the full marketplace. We simply listen to the views that comport with ours. There are silos of information. And so if all we hear is information that's coming from sources that don't have to be truthful about what they say, they can say things that don't comport with reality, it seems to me that everything sort of gets distorted, and there ought to be some other safeguards in terms of what we can and can't say in this digital age, where we don't really avail ourselves of the full spectrum of ideas to be able to allow us to have informed opinions.
Let me say three things in response. First, I've never believed in the marketplace of ideas rationale for the First Amendment. There's never been a true marketplace of ideas. The reality is that those who have money can get their ideas expressed. Those without it have never been able to buy advertising time on television or radio. And I've never believed that if all ideas are expressed, that the true ones will triumph and the false ones will fail. We see too often through history that sometimes false ideas do triumph, at least for a period of time. Second, with regard to what you say, I too am concerned that we tend to listen to the ideas that support what we already believe. But that's always been true. I mean, the internet and social media make it easier to pick and choose what we listen to, but people always are much more likely to listen to what they believe, to read what they supports their views than opposing viewpoints. I'm not sure that the internet and social media in kind make it different. Let me give you an example. Take conservative talk radio. Conservatives are much more likely to listen to conservative talk radio than non-conservatives are. Liberals will probably be more likely to listen to or watch MSNBC than conservatives would be likely to. Conservatives are more likely to watch Fox News. That's not about the internet and social media. That's just about what social psychologists tell us is about selective attention and selective perception. And this leads to my third point. I'm not sure how the government could regulate this to solve the problem without making it much worse. How would the government be able to force any of us to hear things we don't want to hear or read things we don't want to read? Is the government going to suppress views by saying there's too much of this and not enough of that? I'm too distrustful of government power to let them cure the problem. Ultimately, what the internet and social media do is give us an incredible diversity of what we can look at and listen to, and then it's up to us.
Thank you. We have a question from Stephen Levy, who asks, what is the danger if we prohibit hate speech? How does this compare to the danger of allowing hate speech?
It's a great question. There is a huge literature about this. I think that the danger of prohibiting hate speech is that because the definition is so vague and so overbroad, we're going to lose a great deal of speech that we think should be protected. Brigitte Bardot recently died. She was an animal rights activist in her later years. She was the most frequently prosecuted person in France under its hate speech law, and she was prosecuted because of her advocacy for animal rights and her opposing a ritual slaughter of animals. Or another example, in England, when it adopted its first hate speech law, the initial prosecution under it was against a Zionist group, with the prosecutor saying Zionism is a form of racism. When the University of Michigan adopted its hate speech code before it was declared unconstitutional, every prosecution enforcement action under it was brought against African American and Latino students, the groups that it was meant to protect. But I think ultimately the answer to your question is what I said. Hate speech expresses an idea of you. We might detest it, but then the response should be for us to refute it and show that it's wrong. I'll give you an example. Charles Murray wrote a famous book in which he argued that there is racial superiority and inferiority with regard to intelligence. One might regard that as hate speech and could have suppressed the book under a hate speech law. Instead, the book was published, and then there were scathing responses attacking the methodology and showing how silly his approach was. I think that's better than censoring. I think much better to allow the responses to occur.
Thank you very much. We have a question from Hallie Faust. How do you find the line between harassment, i.e. prohibited, and hate speech allowed? And how are you defining that line between the two?
And I think it's important to separate here, when does speech become harassment and what can a university do about it? In the law, there's two kinds of harassment. There's the example that I gave, the quid pro quo harassment, the sleep with me or you're fired. And that's not what we're talking about here. The other is harassment that creates a hostile environment. And the courts here have developed a definition. It's primarily come in the employment context, and that's that the speech generally has to be either directed at someone or sufficiently severe and pervasive to materially interfere with employment opportunities based on race, sex, religion, sexual orientation. I think the same standard should apply in the educational context. The speech either has to be directed at somebody or sufficiently pervasive to materially interfere with educational opportunities on the basis of race, sex, religion, sexual orientation. When it does so, the universities must take action. Title VI of the 1964 Civil Rights Act says that recipients of federal funds cannot discriminate on the basis of race or ethnicity. And the Supreme Court has said this means for an educational institution, it cannot be, quote, deliberately indifferent to a hostile environment. But that doesn't mean that it can punish the speech if it's protected by the First Amendment. But it means the university must do other things. That's why I mentioned the case Feminist Majority Foundation versus Hurley, where the court said even though the students perhaps couldn't be punished for their speech, the university still needed to do things. And there are many things that a university can do in the face of it. So I think in answering the question, I'm both trying to find a definition of when does it become harassment, and then separately talk about what does a university do in the face of a hostile environment.
Thank you. We have a question from Roberta Clements, who asks, would private colleges that receive public government funding be considered to fall under the umbrella of publicly funded university?
Not for purposes of the First Amendment, but for purposes of the federal statute, Title VI, that I just mentioned. Let me explain. The First Amendment applies only to the government. It doesn't apply to private institutions. Even if a private institution gets a great deal of federal money, even if it's 100% federally funded, if it is private, it still isn't covered by the Constitution. There was a Supreme Court case in 1982, Rendell Baker versus Cohn. Rendell Baker versus Cohn involved a private school in Massachusetts that received over 99% of its funding from the government. It provided special education. A teacher criticized the principal and she got fired. Some other teachers spoke up on her behalf and they got fired too. And they sued and they said, given the almost total government subsidy, the First Amendment should apply here. And the Supreme Court said no. The Supreme Court said government funding is not enough to find that a private institution has to comply with the Constitution. But the Constitution is only one source of law. Another, as I said, is Title VI of the 1964 Civil Rights Act. It says recipients of federal funds can't discriminate on the basis of race or ethnicity. There's another law, Title IX, that says that recipients, educational institutions that receive federal funds can't discriminate on the basis of sex.
Thank you. We have a question from Scott Shaper. He says, I am a retired associate dean of a law school and litigated First Amendment cases on behalf of newspapers. How do you reconcile freedom of speech and academic freedom with faculty advocating in the classroom instead of providing neutral content to encourage critical thinking? Of course, I'm speaking of faculty who are pro-BDS and teach their political viewpoint as gospel.
It's an enormously important and difficult question. If a professor is teaching his or her subject matter, the professor has a great deal of latitude in terms of how to teach that material. But if the professor is not teaching his or her subject matter, but is using the classroom for a political platform, then that's not protected by academic freedom or the First Amendment. Let me elaborate a little bit about this. When I teach constitutional law, no matter how hard I try to have both sides come out, inevitably, I'm sure, my views are expressed at times. If a professor is teaching about the Middle East and talking about the Israel-Palestinian conflict, no matter how much the professor tries to be neutral, the professor's views are inevitably going to come out. It's very difficult then to draw the line of what's permissible in terms of academic freedom versus impermissible in terms of proselytizing. I think we give to professors a great deal of latitude in teaching their subject area. But the professor can't use the classroom to proselytize views, and certainly unrelated to what the class is about. I'll give an example from the Berkeley campus. There was an incident a couple of years ago where a computer science professor used the last 20 minutes of a class about computer science very much to strongly criticize Israel's policies. And the professor got censured for doing so. Talking about Israel and Palestinians had nothing to do with his computer science class. The using the classroom in this way was very much an abuse of the podium. There was an instance just in the last couple of months involving that same instructor where a large computer science class, he's an electrical engineering instructor, he dismissed the class ended, and then he continued and did a diatribe with regard to the Middle East. And the provost has said that he could be disciplined for this because, again, this wasn't about teaching his subject matter. This was about using the classroom to express an ideology. So I do think there's a difference between when a professor is teaching a subject matter, having latitude in terms of how to teach it, as opposed to the professor using the classroom for something that's completely unrelated to the subject matter. Within teaching the subject matter, I think it's going to be very hard to draw a distinction between what's permissible and impermissible. But once the professor is using the classroom for outside the subject matter, then I don't see that as being protected. There was recently a decision of the Federal Court of Appeals in the Ninth Circuit, the Court of Appeals for the West Coast, that involved, again, it involved a computer science professor at the University of Washington who used his syllabus to mock land acknowledgments for Native Americans. And I don't think that that would be protected by the First Amendment or Act of Freedom because it had nothing to do with teaching his subject matter.
Thank you. We have a couple questions having to do with banning of books. Given what you've said about free speech, how can the rampant book bans in many U.S. cities and states be allowed to continue?
I am deeply troubled, for obvious reasons, by the banning of books. But let me also try to explain what makes it a hard question. We have a law library, as does every law school. We can't possibly buy every book, and at times we have to weed books off the shelves. We don't buy the literature of the Aryan Brotherhood, and I don't think they could sue us and say, you're violating our First Amendment rights for not buying our literature. We can only buy so many things, and we can certainly choose what to buy or not buy. We don't buy white supremacist tracts. And libraries have to make choices in what they're going to keep on the shelves and what they're going to take off to make room for new books. So, how can we protect the ability of libraries to make those choices while at the same time say that the banning of books on the basis of the viewpoint and the ideology violates the First Amendment? The answer which the Supreme Court has given, and there's a case involving high school library, Island Tree Board of Education versus PICO, was to say that a school can't say that there are certain viewpoints that are unacceptable and going to take down those views, that they can't say any book that espouses diversity or any book written by Toni Morrison will be taken down. The difficulty, of course, is that inevitably schools will make viewpoint choices with regard to books. And how do we draw the distinction between what's permissible and impermissible? I find that to be one of the hardest, most insoluble questions under the First Amendment.
Thank you. Well, we have a question from Daniel Bornstein. What if efforts to require certain diversities conflict with freedoms of academic expression? And what is your perspective on requiring academics to swear in writing that they support DEI in order to join the faculty?
In the 1950s and the 1960s, courts declared loyalty oaths unconstitutional. I think likewise in your question, requiring that faculty members swear oath to any particular viewpoint, including diversity, would be impermissible. I think what makes it harder is that imagine that a university wants a statement that says, we want to know how will you approach teaching a diverse student body. It's not asking that you swear loyalty to believing in diversity. It's recognizing that our classrooms are very diverse. We want a sense of how you'll approach that. just like we want a sense of how you'll be as a teacher or as a scholar. I understand the impetus for such diversity statements. The problem is how they've been implemented has often been much more like what you describe, requiring an oath of fidelity to diversity. And so, in the context of that, I would say I understand why diversity statements are prohibited, but I also understand that part of what we do in assessing who we're going to hire around our faculty is, are they going to be successful in teaching a very diverse student body?
Thank you. We're running to the end of our time, and I'm going to just ask one last question, although we have many more that we won't have time to get to. This one is from Diane Schmidt. She asks, just wait a second, is the government itself protected with regard to free speech in defaming individuals, such as calling Renee Good, recently killed by ICE, a domestic terrorist?
There's so much that's there. One is that defamation is about saying something that's false and injurious reputation of a living person. Somebody who's deceased can't have a suit brought on their behalf for defamation. Second, government officials themselves have freedom of speech, and they can say things like anybody else can that are false. I think here, to go back to the theme of my remarks this morning, that the response should be to expose what's false, to show that what the government officials have said here is just wrong. This is the solution that long ago Justice Oliver Wendell Holmes gave and said, the best remedy for the speech that we think is wrong and we don't like is true speech.
Thank you. Some of our questions actually are commenting on how much they appreciate your remarks and how excellent your talk was.
Thank you.
Thank you so much for your talk, and we look forward to your forthcoming book. Thank you on behalf of the Distinguished Lecture Series.
Thank you so much. Thank you for having me.